Hello, everyone, and welcome to Uncivil Law. And today's case deals with a traffic stop as part of an investigation relating to a criminal misdemeanor, but one that was already complete. In this particular case, the crime had already happened, and the police are pulling over the vehicle not for a vehicle violation, but as part of the investigation into the misdemeanor. And there's a question as to whether or not that's proper, because it would be proper for a felony, but the question of a misdemeanor was left open. So under what circumstances can the police pull over a car not for an immediate violation, but for part of an investigation of a misdemeanor that is already complete? That is the question raised by this case. This is United States of America versus Jermaine Tyrone Jones. And so we're going to get into that case and discuss what the rule is in terms of these kinds of investigatory stops. Let's get started with this. On April the 30th, 2017, Tyerica McKinney called the police department to report a domestic incident. Several officers arrived at the scene. McKinney told the officers that she had come home from work to find her ex-boyfriend, Jermaine Jones, inside her house. She asked Jones to leave. When he refused, they began arguing. Matter got out of hand. Jones poured dish detergent over her couch, then chased her out of the home. Once outside, Jones threw Sprite cans and a bottle of dish soap at McKinney as she ran for help. This is a little weird of an incident, but this is apparently what occurred. McKinney dodged the cans, but did not evade the bottle of dish soap. She got hit by the dish soap. McKinney eventually returned to see William Snipes, Jones' friend, driving Jones away in a white Tahoe-like vehicle with a long body. So this is a domestic incident involving thrown cans of Sprite and thrown bottles of dish soap, and dish soap being poured over a couch. So, that's a thing that happened. Let's read on. Consistent with department policy, the officer and McKinney filed out a form, a questionnaire to determine if the officer should refer the victim to services that could provide some assistance. The person told the officer that Jones had threatened her in the past, might try to harm her in the future, and could easily obtain a firearm. McKinney elaborated that Jones had put her hands around her neck and had kicked her inside of the home. She repeatedly told the police, without prompting, that she planned to get an emergency protective order against Jones, and that she feared he would return to attack her once the officers left. So there were some more direct threats, at least made in the past. And so she said, well, I'm concerned for my safety. I'm going to get a protective order. I'm concerned what happens if you leave. So there might be a pattern of conduct that might be going into something the police might want to take note of. To allay these concerns, the officer stayed in his car next to the house and finished up some of the paperwork. This caution paid off. Shortly after the officer finished up with McKinney, he saw two black males in a white Chevy Suburban sitting at an intersection near the home. So he says, well, I'm going to just do some of my paperwork in the car near the house. I could go back to the station, but I'm going to do it in the car, see if anything happens. And the car, meeting the description, seems to be present. So it's like, okay, well, that's something I might want to investigate. So the officer pulled the Suburban over and approached the passenger side where Jones sat. So Jones was in this car. After a brief discussion, the officer asked Jones to exit the vehicle and escorted him to the officer's car. A quick pat-down of him revealed nothing. Asked about the incident, Jones denied everything. He denied the detergent, the Sprite cans, and the dish soap. The officer did not believe him and arrested him for the assault. So we have conducted an interview of the suspect. He denies everything, but I'm like, I'm pretty sure you did some of that stuff, so I'm going to arrest you for the assault. Which seems perfectly reasonable because we're on a probable cause standard. Assuming that we can do the pullover in the first place is where things are going to get to. But for the actual incident at home, well, we do have evidence. We do have dish soap. We do have some evidence. So, yeah, there's enough to make an arrest here. After he cuffed the suspect, he conducted a second, more thorough search and placed him in the back of a car. Jones began yelling that the officer had cuffed him too tightly. When the officer checked the cuff, he spotted a firearm in the back of the cruiser that he had not seen there before. That led to a charge of an unlawful possession of a firearm. Okay, so we have to wonder how this firearm got there, because we've patted down this guy twice. And we patted down him once when we initially did it as part of a Terry stop, which is probably lawful. Then we've decided to arrest him. So now we can conduct a more thorough pat down than we would before because our justification became greater. And we didn't find anything. However, when we went to check on the cuffs, we've now discovered a firearm that fell out of his pocket or whatever. So we're not very good at the pat down, but we now found a firearm on possession of this guy, having failed 2 different pat down efforts. It somehow is just sitting there on the stool of the car. So great work by the police on the pat downs, but you know. Anyways, we've now discovered a firearm, so that's good news. Our recalcitrant suspect here moves to suppress the firearm. The officer violated the Fourth Amendment, he claims, because he stopped the vehicle on suspicion that he committed crime. To make a valid stop, he asserts, the officer needed a reasonable suspicion of ongoing or imminent criminal activity. So you couldn't pull me over because this was a complete activity. All right? It's not imminent, it's not ongoing, it's complete. All right, so you can't pull me over. That's the argument. At the hearing, the officer confirmed that he had stopped the vehicle solely to further investigate the alleged assault. In Kentucky, her accusation amounted to a 4th-degree assault, a misdemeanor. So we are conducting this traffic stop not because we saw him violating the law, not because of an imminent threat, not because of an ongoing threat, but because of a past complete crime. And it's a misdemeanor, a 4th-degree misdemeanor. So the question is, can we do that? Can we pull over his car and conduct that initial seizure from which all this information flows based on a past incident? So if we can't, presumably we have to suppress the firearm. If we can still presumably arrest him, but we have to suppress the firearm. So the question is, can the firearm come in or not? That is the operative question. So let's read on. Relying on some dicta, which is legal language for non-binding authority. So courts muse, and when they muse, it's called dicta. So it is suggestive, but it's not binding. So relying on this non-binding authority from 2 of our decisions, the trial court reluctantly suppressed the evidence and the government appealed. So the trial court said, no, you can't do this based on some passing language in some other cases. But the Court of Appeals has a chance to revise that. So let's look and see what the court does. The Fourth Amendment protects the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. When an officer stops a vehicle and questions the occupants, even for a brief moment, that counts as a seizure of the person. But what happens if an officer stops a vehicle to investigate a criminal activity that's already occurred, which is to say, activity that is complete? We know the answer in part. If the activity qualifies as a felony, the Fourth Amendment does not bar the stop. But what about a non-felony crime, which is where we are? Does the Fourth Amendment prohibit officers from making a Terry stop to investigate the misdemeanor? Active readers of the Fourth Amendment case law should be skeptical of the standard. The touchstone of the Fourth Amendment is reasonableness, not a bright line rule. All right, so we have to talk a little bit about a Terry stop and what that is. So most traffic stops are considered to be Terry stops. So you're not under arrest even though you've been seized. So a Terry stop allows an officer to conduct a brief investigatory stop of someone based on reasonable suspicion rather than probable cause. So it's a much lower standard. So reasonable suspicion is probably something like, on a scale of 1 to 10, probably something like a half or maybe a quarter. It's not very much, but it's something. So you need a reason to conduct this seizure. And that might be the problem because you didn't have a reason to conduct a seizure. When you stop the car for anything, that was a seizure. It may be a Terry stop seizure, but it's a seizure nevertheless. And so you have to have reasonable suspicion. So did you? Can you conduct it for that reason? Now, if it was a felony, we know the answer to that question is yes. But this is a misdemeanor. And the court is thinking ahead. They're thinking about the problem because people commit all kinds of crimes all the time. And so there might be a time frame problem. You know, if the police could pull you over for any misdemeanor anytime, then the Fourth Amendment would basically disappear, right? Because everyone commits misdemeanors probably every single day. There's a lot of them. In fact, people probably commit felonies every single day because there's so many of them, but we'll look past that issue. So if they could stop you at any time to investigate any past misdemeanor, that would be a problem. So we are trying to look ahead and say, okay, well, what can the police do and what can't they do when it comes to a completed crime where that completed crime is the misdemeanor? Let's read on. The Supreme Court said in a case called Hensley that the proper way to identify the precise limit on an investigatory stop to investigate past criminal activity is to apply the same test already used to identify proper bounds of intrusions that further investigations of imminent or ongoing crimes. Now, that case did leave open whether Terry stops to investigate all past crimes, however serious, are permitted. So, does it matter how serious the crime is or how long ago? But the case law did not erect an automatic barrier to investigating completed misdemeanors either. The court left it open to lower courts to apply traditional Fourth Amendment considerations rather than create an inflexible rule as if and when the question of investigating a complete misdemeanor or other non-felony crime came up. So the touchstone of the Fourth Amendment is reasonableness. What is reasonable and what is not reasonable? So the Supreme Court left open this language. They said it's up to you to figure out what is reasonable and not reasonable, and that's going to be fact specific. And so it may not be reasonable to investigate all kinds of misdemeanors or all non-felonies the same. And it may not be reasonable to investigate them all in terms of time the same, how long ago it was. So the proximity in terms of time and the seriousness may be guidelines to determine what the police can do with respect to any particular situation. An across-the-board prohibition on stops to investigate completed non-felonies runs into problems, including the elusive and evolving nature of felony misdemeanor distinctions and its disappearance in some instances. So what are felonies and what are misdemeanor is more of a blurred line under the law this day. While in earlier times the gulf between felonies and minor offenses was broad and deep, so what a felony was and what a misdemeanor was used to be pretty clear, today the distinction is minor and often arbitrary. Once upon a time, felony described the most severe crimes. No crime was considered a felony which did not occasion a total forfeiture of the offender's lands or goods or both, or more directly, was a capital crime. So felonies used to be the most serious kind of crimes, and we have blurred that distinction. So today, serious crimes are usually felonies, but not always. In Kentucky, where Jones' arrests occur, it is a misdemeanor to, for among other things, incite a riot, possess burglary tools, stalk someone, or flee the police. So, yeah, we see this all the time. And some of these distinctions get really, really weird. The classic distinction between a felony and a misdemeanor was a year in prison. And if it was under a year, then you did jail. If it was more than a year, you did prison. So traditionally, prison was for felonies and jails was for non-felonies. But that distinction has become a little bit lost. We see misdemeanors with multiple years sentences sometimes. And we say felonies with I don't know that there's any felonies under a year, but it wouldn't surprise me. So these distinctions are a little bit blurred. And also the number of things that are felonies are also much more than they used to be. Felonies used to be pretty much synonymous with capital offenses. It has gone a little bit beyond that. So a lot of things are felonies. So for all of you who say, well, I'm not a felon, it's like, are you sure? You're really sure? Because I probably are. A lot of things are felonies. You might be surprised. So if you ever watch the Twitter account Crime a Day, it will give you an idea of how many crimes there are. There are quite a lot. Some of the things you would never expect, man. There are crimes everywhere. So yeah, these distinctions are not as helpful as they used to be. The better rule in this setting is not bright in either direction. So we're not talking about a bright line rule or an absolute rule, but rather something that's more measured, more case specific. It does not say officers always make a Terry stop of a known individual to have completed misdemeanor, as Hensley commits for completed felonies. So any completed felony would be fine, so we're not going to go that broad. And it's not say that officers never make a Terry stop of a known individual to complete a misdemeanor. So we're not going to say always, we're not going to say never. We're going to say something more ambiguous in between. Instead, we fall back on reasonableness, balancing the inquiries of public safety and personal liberty. The inquiry turns not on this technical distinction of whether the crime is complete as opposed to imminent or ongoing. So not about to happen, not is happening, not has just happened. So we're not looking to that technical distinction. So that's not the barrier. It turns on the nature of the crime, how long ago the suspect committed it, and the ongoing risk to the individual and to public safety. Under this approach, the Fourth Amendment correctly appreciates the distinction between officers who illegitimately invoke Terry to stop someone who ran a light 6 months ago, that's not going to fly, and legitimately used to stop someone who assaulted somebody in the last half hour. So yes, we've set out some rough markers here as guidelines, right? In the case of a felony, it's always. So whether it's complete or not is irrelevant. Yes, we can always stop you for the felony, no problem. In misdemeanors, no, we're not going to say always and we're not going to say never, because either rule would be stupid. If we said always for misdemeanors, then you could pull over anyone pretty much at any time. And if we said never, then we couldn't pull you over for fairly serious misdemeanors. And as I was saying earlier, some misdemeanors are fairly serious. I've seen misdemeanors with 3-year jail sentences. I've seen misdemeanors with 5-year jail sentences. I've seen misdemeanors with all kinds of ranges. So some of these are more serious, and some of them happen closer in time. And so the court says, look, you can't pull someone over because they ran a speed light 6 months ago. That's not going to work. But you could pull them over because they ran a light a minute ago. I mean, the crime is complete, but you could still do that. That would make sense. And in the same way, yeah, if there's a serious incident, such as the one we have here, a domestic situation, and it occurred in the last half hour, and I don't know if that's the actual time frame, that seems a little thin. I think based on this fact pattern, it seems more likely you're talking about an hour, but it's kind of a distinction without a difference. If it happened closely enough in time, yeah, you can do that as part of your investigation. And the police came, they did their report, they're doing their paperwork, and the guy comes back. So you're talking about something on the order of minutes to maybe an hour and a half, depending on police response time. You're not talking about a huge amount of time. So yes, this was a proper stop. That's fine. Based on these considerations, this particular stop passes the test. At the time they pulled Jones over, the officer had a reasonable suspicion that Jones had done the assault. He corroborated almost every part of the account, and he saw a car that matched the description. Stopping the vehicle directly promoted the interest of investigating this and preventing crime. McKinney credibly alleged that this person had intended to harm her or the home. Thus, we reverse and allow this to be admitted against this particular person. Thus, this is the end of our coverage of the case of United States of America versus Tyrone Jones. And this was a very interesting question as it relates to when and how the police can conduct certain kind of stops in relation to crimes, particularly completed crimes. So not ones that are anticipated, imminent, not ones that are ongoing, but completed. Ones that have already occurred and are in the past. And here the police pulled a guy over, not for anything he was doing right that second, but for a serious misdemeanor that had occurred in the relative contemporaneous past. You know, something on the order of minutes to maybe an hour, hour and a half, depending on the response time. And the court looks at this and says, yeah, this is reasonable, which is the touchstone of the Fourth Amendment. The Fourth Amendment only prohibits unreasonable searches and seizures. So they look at this and says, yes, this was a fairly serious crime. Yes, there's a credible allegation of ongoing threat. And so, yes, they can conduct this Terry stop to do the investigation. Having done the Terry stop, the officer can then choose to arrest because they have probable cause based on the allegations. And then, of course, all this evidence can be admitted against him. The significance of the evidence, of course, has yet to be decided, but the evidence is available to be. So you could use this firearm that was discovered as evidence of intent to commit more serious crime. If he's a felon in possession, you could use it in that way. So for whatever value it might have in terms of the criminal process, you know, it can be admitted. And maybe it ultimately doesn't mean anything. That's for a trial court to figure out. But it can be admitted as evidence at trial. And so the court erred in excluding this, goes back to trial, and it can be admitted. And that's the end of the coverage of this case. Thank you so much for being part of the Uncivil Law family. I appreciate your continued support. If you haven't already done so, please subscribe to the channel, and you can also support us financially by clicking the applaud button below. Thank you so much for your contributions to our channel. It helps our work grow. Until later, cheers and goodbye.